2 states, one is Arizona, and I don't remember the other, and does not allow that to happen. But for most places, that is what happens. It does say that the House of Representatives can create its own rules of conduct. It can elect its own speaker. And then the House has the sole right of impeachment. Now, please understand that impeachment is the same as the word indictment. Impeachment does not mean that you are guilty. It means that there is enough evidence that a trial needs to take place. So if you or I were thought to have committed a trial, some kind of a crime, we would have to be brought to trial by having a certain amount of evidence presented and then an indictment returned. And impeachment must start in the House. Because again, this goes back to it's the representatives of the people, and the people have given their power to these individuals, so it is the people and their representatives that must be in the position to recall that individual. Section number 3. Sherry, speak out. It's a little bit long.
Okay. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature.
Now, I'm going to stop you right there for just a moment because we want to take a look. This was something that was in place until 1915 with the 17th Amendment. Remember that Polybius had so much confidence in his writings that they were looking at a way to represent not only the interests of the people, but the interests of the states. The checks and balances were critical, and what they saw was that the state had an important role in trying to check the actions of the federal government. Now, not being political, but just by an example that we're all aware of. Back during the health care debate, you and I were probably aware how many governors were writing letters. They were making public statements to their senators, asking them not to pass the health care bill because of their concern for what it was going to cost the states and what the effect it was going to have on the states. At one point in our history, the legislature of a state would have had a vehicle to tell the person, if you don't represent our interests, the interests of the state, we're going to recall you. In 1915, with the 17th Amendment, that was lost. And sadly, the Senate became not a whole lot more than just a really aristocratic debating club at that point. There's still a little bit of a check and balance there. But originally the idea was you'll have one house representing the interests of the states. You'll have another house representing the interests of the people. Changed in 1915. 6-year term. Go ahead, Sherry.
Thereof for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the second class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year.
So what happened at that point is that they kind of drew straws. And now we have about 1/3 of the Senate that stands for election at any one time. So you never have the entire turnover of the Senate at one point. And it goes back to the states. At that point, who drew the straws? Then we've had a kind of a perpetual system of every 6 years since that point.
So that 1/3 may be chosen every 2nd year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers and also a President pro tempore in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law.
Essentially, what we've heard there is this. One of the checks and balances, one of the ways in which the legislative and the executive branch work together is that the Vice President of the United States serves as the President of the Senate, sits up there and conducts day-to-day business within the Senate. In the event there, however, is a reason for the Vice President to be about other duties, then the Senate itself will elect what's called the President pro tem or pro temporary. He's a temporary president. He's serving in that position when the Vice President is not presiding. The Vice President may not vote unless there is a deadlock, an absolute, in this case 50 on either side, then the Vice President would cast the vote. That is one way then that the interests of the President are also represented within the Congress. In the event that the House brings an impeachment, an indictment, the Senate serves as the jury. They listen to the arguments, they listen to the evidence that's being presented, and then by a 2/3 vote must convict, which would remove the person from office. Our founders, however, were very wise. The Chief Justice presides in an impeachment trial. So the guy who is hoping that he might become President of the United States is not in a position to cast a deciding vote in his own favor. So the Vice President is removed from that decision-making process. What the Constitution is telling us there is, although the only thing, however, that the Senate can do is remove that person from their office. If there is the need for criminal prosecution, that has to be done under the laws of the state or under federal law in court. All the Senate can do is remove a person from their position of authority and leadership. They may not send someone to jail or fine them and so forth. It's limited to that. Section 4 now is a little shorter, and it's going to talk to us about how the states have the responsibility to prescribe and oversee the elections.
Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day.
Now, this is interesting to the way of thinking we have today. Congress is a full-time job. They're there all the time, making mischief, thinking up things to foist on the unsuspecting American public. And they're not only there year-round, some of them are there for 8, 10, 20, 30, 50 years. Interestingly, historically, many of the people who were called on to serve in Congress and in government early on saw it more as a burden than a career move. And consequently, our founders felt it was important that they be required to meet at least once a year, or else they might not have done it. And they did make it by the first Monday in December. That is changed by the 20th Amendment when we get to that point. But they felt it was necessary to let them know, all right, and the manner in which it will be prescribed. This is why we have today the position of Attorney General is extremely important, because in most of the states, it is the Attorney General that directs the election, the state boards of election, and so forth. So that makes what happens in a state and locality very, very important. Section number 5 is a little bit, well, it's not too long. Essentially what we're going to hear is that each house, whether it be the House of Representatives or the Senate, has the responsibility to judge the return and the qualifications of its own members. Do you remember after President Obama was elected, that left a senatorial seat vacant in Illinois? And then we had the whole thing with Rob Blagojevich, or however you name him, this was the way this was his retirement fund. It sounds like he wanted to sell that seat to the highest bidder. And so they eventually named a person by the name of Roland Burris. Yeah. But when Mr. Burris came to the Senate with a letter from the state of Illinois, supposedly, I guess when he got there first, he didn't have the letter yet. And there were the sergeant at arms. I watched all this. I got no life, so I watched this all on unfolding on Fox News and so forth. He made a ceremonial attempt to be seated in the Senate, and they wouldn't let him be seated because he didn't have the proper credentials. Well, this is what was going on there, was that the Constitution gives each house the right to determine the validity of the credentials that someone presents as their proof that they are in fact the properly elected or appointed candidate to that position. Each house judges their own election returns. The majority must be present to constitute a quorum. However, again, they took into consideration that there might be people that don't show up for votes. Who would never believe that?
Oh, really?
And so they said, we may have to have an attendance committee. We may have to have people who are appointed to go around and find out why people aren't here to vote when they're supposed to be. And if you have people that are absent because they're on the attendance committee, then we can adjust the quorum based upon the fact that they are about the job that they are being given to do, is essentially what that's saying there. Each house may establish its own rules, its own proceedings, may punish its own members, and can expel an individual upon a 2/3 majority. We have right now, I think, Charlie Rangel, House investigation, Maxine Waters, some others that are undergoing investigation for the breaking of House rules. Now, under the Constitution, if I understand it correctly, the most the House could do would be to give them the boot. If they've done anything really illegal, then they would have to be tried in a court